As it's preparing the live stream, it looks like it's going through. I've got my fingers crossed.
Alfred, great to see you. You're muted, but that's okay.
Okay. It shows that we went live to YouTube.
All right, so we're good to go. Everybody ready? 10:03. Are we live yet?
Yes, sir.
Okay, thank you. Thank you, Ms. Gonzalez. All right, board members, staff, welcome. I'll call the meeting of the Texas Board of Law Examiners to order. It appears that we do have a quorum. We have no excused absences, so we're good. Agenda item number 2. I'm going to beg for your forgiveness. Ms. Gonzalez always does a great job of getting the minutes drafted for my review with plenty of time, and I just haven't had a minute to complete the minutes. So we're going to defer the minutes until our next board meeting. Agenda item number 3, consider communications from the public, if any. Are there any members of the public that would like to comment?
We do have 13 people in the waiting room, Chair Rivera.
Okay.
Kai, would you like to do the admissions the way we've been doing them previously?
Absolutely, that sounds fine.
As a reminder, the minutes are they're allotted. Each speaker is allotted 1 minute to present public comments. And Ms. Gonzalez is our timekeeper.
All right, let's see. Looks like we have first up for public comment will be Christopher Taylor.
Okay, is that's not showing up on my screen?
Okay, looks like Mr. Taylor just dropped out.
Okay.
Let's see. Looks like Pearl D. Cruz appears to be connecting.
Okay.
There we are.
Good morning, Ms. Cruz. Can you hear me?
Good morning. I can hear y'all. I apologize. It seems like there's some technical errors, but if y'all can hear me, then I guess we can get started.
I can hear you. You have 1 minute for public comments. Thanks for being here this morning.
Thank you for having me. Good morning. My name is Pearl Cruz, and I'm a graduate from St. Mary's University School of Law. Thank you for allowing me to speak today. I want to begin by saying that in all respects, I'm a first-generation graduate. Hard work was always essential for me to succeed. I'm not here to condemn or place blame, but in hopes that you'll take our comments into consideration. I was originally scheduled to sit for the July exam and have grave concerns with the 2 remaining options. Neither seemed practical during a pandemic. The only method proven to stop the spread of COVID-19 is social distancing. September does the opposite. October, while attempting to social distance, has many technical issues, especially now in using ExamSoft. Moreover, the exams themselves are quite different, both in their format and that September's in person, while September's in person with a proctor, and October's online, potentially not proctored at all. At this point, it seems that either exam measure how well one is doing during a pandemic, and thus an inequitable measure. If the goal is truly equity and providing recent grads with the opportunity to move forward in their careers, the Dean's Apprenticeship proposal is our best option. I do not speak for our deans, but I believe they stand ready, willing, and able to answer any questions and to assist in the implementation of their proposal. I respectfully request that the BLE vote to recommend to the Supreme Court the Dean's Apprenticeship option. Thank you all.
Thank you, Ms. Cruz.
Next, we have Kate Willis.
Ms. Willis, good morning. Hi.
Good morning. I've timed myself to 1 minute too, so please bear with me. I have 3 quick points. First, students are now almost 4 months post-graduation and have been studying even longer. According to National Juris, full-time studiers should begin 9 weeks prior to the exam. I've been studying 19 and a half. Please remember that the programs we're preparing with are not meant for long-term memorization. It is a massive influx and outpour into exams and then move to career. Students are facing loan debt, full-time study, and earning enough income to support themselves and families. The mental pressure law grads are going through professionally and financially is nothing short of the unconscionable standard we have dutifully learned. Next, the Dean's proposal. I would like to highlight the 8 states in our country that allow apprenticeship style admission and also the 2 who require law school apprenticeship and apprenticeship, New York and Maine. Both states' requirements are met and surpassed by the proposal from the deans. Lastly, I have a question to the board and current attorneys. We have learned for 3 years that as a self-governed profession, we must hold ourselves and our peers to a higher standard. If that is true, why are we keeping zealous advocates out instead of letting qualified candidates join and contribute to our community? Let us hold each other to that standard. Let us govern ourselves not just as reasonable people, but as the lawyers we've been taught to be. Thank you.
Ms. Willis, thank you very much. Appreciate your time this morning.
Next, we have Rohit Dar.
Dhar, good morning.
Well, Mr. BOE, I just want to make a few points clear. So as of today, when the Louisiana could have hosted its bar, it was moved a week later because in light of tropical storms that will make landfall in Louisiana and possibly in Texas. And so I'm wondering if that's considered, I'm advocating that you should consider that in terms of if we can minister both September and October, depending on how serious the storms are. You also have to consider the plan offered by the deans that can help ameliorate your concerns about public safety, because for us to and we're supervised by an attorney that's taken the authority and thus is minimally competent to evaluate, supervise, and to judge our work. And not only do we do 360 hours of work, you also
Excuse me, there is a message for you.
20 hours of CLE, I believe, James A. Baker course. And so for the apprenticeship plan, I believe and I urge the ability to consider and recommend this plan wholeheartedly to the Supreme Court, especially in light of the fact that at least 2 justices did consider the apprenticeship opportunity for law students to take upon in lieu of an exam.
Rohit, thank you very much. Good to see you. Appreciate you being here this morning.
Thank you.
Next, we have Alan Braddock.
Mr. Braddock, good morning.
Good morning. Thank you all for allowing us to speak today. My name is Alan Braddock. I'm a class of 2020 graduate from the University of Virginia School of Law. I'm a Texas native and returning to Texas to practice. And I ask you today, just what is y'all's backup plan if the October bar exam is unable to be administered? Originally, I was scheduled for the July bar, but after that was canceled, I signed up for the October one because it was supposed to be pandemic proof. But now it's possible the October bar exam may not occur. And I'm just worried that once we get to October, we'll be told just to wait 4 months for the February bar, study for the UBE now, and then wait 2 more months after that to find out if we're even licensed. I cannot afford to not work that much longer. I know today you're considering the apprenticeship program. Ask y'all to seriously consider it, flesh out the issues, add to it whatever you think will make us competent, just whatever is necessary. But whatever you decide, please just have a backup plan. We've been in limbo for months and we're tired and we're broke. And I just ask you to just please have a plan if October cannot occur. Thank you.
Thank you, Mr. Braddock. Appreciate it. Welcome back to Texas.
Thank you.
Next we have Dean Barry.
Dean Barry, good morning, Mike.
Good morning. How's everybody doing?
Hanging in there.
Happy to follow a University of Virginia graduate. A handful of thoughts real quickly. Number one is following up on the comment about backup plans. We reopened campus this week with backup plans on top of backup plans, and fully optional. Any faculty member or any student who can't or does not want to come in does not need to and can Zoom. The backup plan for October is uncertain at this point, and having people hang out until February is not a reasonable option. So I encourage us to have a backup plan for everything. Second is I ask everyone, please to recognize that so much has changed since we took the bar exam in terms of the debt levels that students have, the job market that exists now. It is a very different world from when I took the bar exam in 1992. And being aware of that and being sensitive to that, I think is crucially important. I want to follow up on a comment made the other day about public safety. The most recent information we have on the 2-year passage rate of students who took the bar is for those who graduated in 2017. And there are always 2 schools that are talked about as having low initial pass rates. From those 2 schools, from the 2017 pool of graduates, a grand total of 31 of them have not passed the bar as of 2019. 31 out of some 2,400 students who are planning on taking the bar exam. Students do go ahead and continue to persist and do pass the bar exam. So please make sure that we're sensitive to the barriers that we are putting up in front of qualified candidates, as opposed to only considering the potential risk to the public. Also, a comment that was made on Thursday is that there's more study necessary for an apprenticeship model. And we agree. If we were to adopt an apprenticeship model for a full-time, this is the only thing we need to do for a bar exam, absolutely. But we're not talking about making this the only mechanism by which people are licensed. We're talking about a one-time exception. And the final thought I would suggest, and please ask, is we need to begin planning for February as well. We hired an epidemiologist to come in and help us prepare for opening our school. The information that he provided and that is consistently out there is we will not have a vaccine through at least until the early part of next year, and then it's going to be rationed. So we are going to be addressing these issues through the spring, and we need to have a plan for the February bar exam as well. And I would encourage us to start making our plans, get the task force group together to start thinking about what to do for February. The actions that have been taken in other states, New York canceling without a plan, Florida canceling on the day of the eve of the bar exam, less than 60 hours before, without alternatives, leave students in limbo, and that's unconscionable. We should be preparing now for that eventuality and ensuring that we have plans on top of plans for what we will do should September and October not be able to go as planned, as well as in February. Thank you for the indulgence and allowing me to exceed the minute.
Thank you, Dean Barry. Good to see you, Mike.
Next, we have Cody Miller.
Mr. Miller, welcome.
Good morning.
Good morning.
My name is Cody Miller. I speak today as a fourth-year medical student, a bioethicist, and as a health law LLM student. I also speak both as the fiance of a recent law graduate in Texas and as someone whose parent now has permanent scar tissue in her lungs because of the coronavirus. I urge this board to revise its recommendations to the Texas Supreme Court in favor of either apprenticeship or diploma privilege for 3 reasons. First, the September in-person administration of the bar recklessly puts human lives at risk. Evidence shows the coronavirus is most infectious and transmissible before symptoms even occur, and using open-door hotel rooms without masks has not been proven to reduce risk. The lives of our graduates should not be the guinea pigs of untested mitigation methods. Second, the October online exam is not only unequitable, but is infeasible and dangerous. Online exams have failed in multiple states, and ExamSoft itself is currently being investigated by the FBI for cyber attack concerns. Third, further delays in licensure, as Dean Barry has pointed out, unconscionably suspend graduates in financial limbo. We have no income. Our rent is due. Our jobs are delayed, and our student loans have long since evaporated. Finally, Justices Boyd, Busby, Bland, Green, and Chief Justice Hecht and every law school dean in Texas all support either apprenticeship or diploma privilege. I beg this board to do the same. Please recommend apprenticeship or diploma privilege to the court. Coronavirus has already hurt my family. Do not let it hurt anyone else. Thank you.
Thank you, Dr. Miller.
Next, we have Hayden Carlos.
Good morning.
Morning.
Excuse me, there is a message for you.
Thank you all. I'll keep my comments under the minute. For over 6 months, we knew COVID would be a barrier to a successful bar exam and our normal admissions practice, and this board has had a plan in front of it to address this problem for 8 weeks. We understand you're bound by the Supreme Court's directive to administer a September and October exam, but you have the ability and opportunity to advocate for a more equitable solution. I understand you have concerns with admission without an exam, but we have answers. If you're worried about apprenticeships being limited to a mentor's practice area, make us take more CLE hours or participate in the Texas law course. If you're worried that you will be discouraged by having an asterisk by our name, we won't. We'll have the opportunity to work, and that's all we want. If you're worried about a lack of information and studies of apprenticeship programs, we understand. But that cannot excuse that we also lack information and studies about the success of an online exam or a hotel exam, and have evidence that these exams will likely disproportionately burden a large number of us or fail completely. You have the ability to do what all lawyers seek to do: provide a just and equitable solution to a problem. Please do that. Thank you.
Thank you, Mr. Carlos. Appreciate you being here.
Next, we have Anya.
Hi, can you hear me?
Yes, Anya, we can. Welcome.
Hi, my name is Anastasia Bolshakova, and I'm a graduate of the University of Houston. As a September examinee, I implore the board to develop a plan for contact tracing ahead of the exam. It was disappointing to hear examinees from July administrations disclose that they were not provided with any means of reporting their potential diagnoses. By tracing the contacts of COVID-19 cases, getting them into quarantine, and when necessary, testing them for infection, we can slow the spread of the virus. However, if examinees have nowhere to report infections, mitigation efforts will be stifled, and Texas, like other jurisdictions, will not have an accurate count on how many examinees were exposed. September examinees need to know ahead of time how and to whom to report their positive diagnoses. While there are inherent risks associated with an in-person exam, examinees deserve the assurance that if a proctor or another examinee tests positive, there is a plan in place to quickly notify others that may have been exposed. It is our collective responsibility to do all we can to stop the spread of this virus. I thank you for your time and consideration.
Thank you. Thanks for your input.
Next, we have Brandy Wolf.
Ms. Wolf, good morning. Hi.
Hi. This morning, the entire online learning interface for Northside Independent School District in San Antonio crashed. They've had since March to prepare with a $1.5 billion with a B dollar budget. I believe foreseeability of ExamSoft failing has already been established. 30,000 in one day is not likely to work after failing for under 1,000 in Michigan. As such, the next issue to present itself would be equity between the cohorts. If ExamSoft fails or backs out after September has finished, what then? And one relevant and reasonable method to address this issue would be apprenticeship, entrusting the deans and law schools to help find partnerships with students is logistically feasible. They've assured us they have their plan. They've talked to the bar associations, and I trust Dean Barry and Dean Roberts implicitly, as well as the others, but I have experience with the two of them. In the last 3 days, I've discussed this present issue with 20 plus attorneys. Most didn't know what was going on because they're not talking. There's no water cooler chatter or anything like that. And I'd say over 3/4 were willing to take part in an apprenticeship program. I think it's critical that apprenticeship be considered with the dean's letter as the only viable, equitable form of gatekeeping left. And respectfully, time is running out to make that decision. So thank you for your time.
Thank you, Ms. Wolf. I appreciate it.
Next, we have Michael Aragon.
Sure, Aragon, welcome.
Good morning. Regarding item number 7 on today's agenda, I asked the board to recommend that Texas accept scores from jurisdictions offering the October 5th and 6th bar exam provided by the NCBE. In past meetings, this has been referred to as the mini UBE. Texas would find itself in good company as 12 states and DC have already joined a reciprocity agreement to accept these mini UBE scores. One last important point, the mini UBE will consist of the same half portions of the MPT and the MBE that will be administered as part of the Texas October remote bar exam at the same time on the same days. The only difference between the exams is the essay portions and the unique Texas components. And that's the same situation that would have happened if the July Texas bar exam and July UBE had gone forward as planned. So please support agenda item number 7 and recommend to the court that Texas accept those mini UBE scores. Thank you.
Thank you, Michael.
Next, we have Gwendolyn Bennett.
Good morning, Ms. Bennett.
Oh, sorry, Ms. Bennett, you're muted.
How's that?
Better, thank you. Good morning.
Great. Good morning, ladies and gentlemen. My name is Gwen Bennett. I am a proud graduate of UNT Dallas College of Law. You are confronted with a unique disaster no one could have anticipated, and you must confront it with a solution that is just as unique while ensuring you measure minimal competency to practice law. A law degree confers that minimal competency. Section 1.01 of the Texas Disciplinary Rules of Professional Conduct says competence is defined as possession of legal knowledge, skill, and training reasonably necessary for the representation. It would be in keeping with the expediency of the circumstances and the Texas Disciplinary Rules of Professional Conduct to exercise a one-time recognition of diploma privilege, or in the alternative, an apprenticeship, so you can fulfill your duty to the citizens of Texas to make sure that lawyers representing members of the public are qualified in a way that will bring honor to the profession. Thank you.
Thank you very much, Ms. Bennett. Appreciate you being here.
Next, we have Thomas Samuelson.
Mr. Samuelson, good morning.
Mr. Samuelson, looks like you're muted. Well, we can't hear your audio.
We can see you, but we can't hear you.
Okay. Next, we have Mr. Ryan Mack.
Mr. Mack, good morning.
Good morning. My name is Ryan Mack. I'm a Texas native and a 2020 graduate of Harvard Law School. Like many graduates with state and federal clerkships across Texas, I've already begun working. In the morning and afternoon, I work on real complex legal issues. At night, I study for a bar exam that should have been finished well before my clerkship start date. I'm not complaining about my personal circumstances. Other students would gladly be in my position rather than face down student loans and rent without a source of income. But it goes without saying that my work has detracted from my study. But more importantly, my studying has detracted from my work. If public concern is, if the safety of the public is truly concerned to the BLE, please consider those of us that are already working and would like to dedicate our full time and effort to serving the public directly. For those who have concerns about the plan created by the Texas Deans, I hope you look to improve on the plan to address your concerns rather than dispose of it entirely for failing to meet your standards. I urge the board to recommend an apprenticeship option either in its entirety or modified to their liking. Thank you.
Thank you, Mr. Mack. Appreciate you being here.
Looks like Mr. Samuelson's gotten back on. Let's see.
Mr. Samuelson?
Is it working?
It is.
Oh, perfect. So I would propose actually a four-pronged solution. You keep the in-person, you keep the online, you keep the supervised practice, and then you just throw on the apprenticeship on the back end. The benefit of this would be as follows. First, all the students' work wouldn't go to waste, but also in terms of the apprenticeship, the quantity of individuals would decrease the risk because some people would move over to apprenticeship. With the online situation, you would have less people on the server, so a little bit better chance there. And then in regards to some of Cynthia's questions in the last meeting about equity, the solution with this would be is it shifts the burden onto the applicants to make adult decisions about what's best for their families. So if we take the least equitable decision for us and our families, that's what we have to live with. And the same thing with reciprocity that Barbara brought up last time, as well as the asterisk. This would be able to shift the burden onto us. If we make the mistake, we make the mistake. But the benefit would be is we would have options. Furthermore, the benefit would be is that we would be able to get money coming in. A lot of people need money coming in, got rent due. A lot of people lost their health insurance recently, and it would provide more solutions than anything. Thank you.
Thank you, Mr. Samuelson.
And that appears to be everyone in the waiting room. There's only one person in there, and that person has already spoken once today. So,
okay. Thank you, Mr. Strauss. Thank you, Ms. Gonzalez, for your, as always, fine work in getting everyone in. And to everyone who gave public comment, thank you all very much for coming and sharing your input this morning. Rest assured that even if it doesn't appear that we address anything specifically you've said, that we are listening. I'm looking down because I'm taking notes and making sure that I document what everybody said, and we do appreciate obviously your intense interest in this and making the time to come before us. Just to set it in the right context, board members, I mean, if you, like me, felt like a little bit like deja vu, it's because just to be clear, we did meet last Wednesday, and we had a lot of public comment on the issue that we have down. This agenda that we have for today's meeting was actually prepared before the emergency one that we considered last Wednesday. So if it feels like we're covering some of the same ground, we are, but that's not to say that we don't have new thoughts on ground that we've already covered today. But let's go ahead and pick up then on agenda item number 4 is the report of the executive director, Ms. Hendricks. Susan?
Yes, thank you, Chairman Rivera. As far as general agency operations go, most of the staff are still working remotely. I'm in the office today. Nadia's here. We've had a few people coming into the office to do preparation for the September examination that, you know, simply has to be done here in terms of assembling supplies and preparing materials that we need for the exam and arranging for the delivery of the examination booklets to the different sites. So that is proceeding. The Facilities Commission has posted signs throughout the building advising people how to maintain safe distance, requiring people to wear masks. And I think it's a very safe environment here at the office. But as I said, most people are still working at home. As far as the September and October bar examinations, the plans are in place for those exams, and they are proceeding without any difficulty. We have assembled supplies. We're still recruiting proctors for the September examination, where we will need live proctors in person, and we're going to be reaching out to a staffing agency to help us fill the remaining slots for the proctors. But if you know anyone who you think might be interested in working as a proctor, we are still taking applications. But the contracts are all in place, and everything is being assembled, and so we feel confident that the September examination is going forward. The October examination, the board approved the ExamSoft contract last Wednesday, and we will be executing that probably today or tomorrow. ExamSoft has agreed to the modifications that we requested. We've done further evaluation on ExamSoft and their capacity to complete the online examination. We've attended a webinar where they talked about the product and explained how it works and answered questions. We view the Michigan examination as having been a successful demonstration of the ExamSoft product because 99% of the applicants completed the examination. There was a 30-minute delay because of the cyber attack, but you know, quite honestly, delays happen in the bar exam, even under the best of circumstances due to weather and various disruptions that may occur at the site. So that's not an unheard of problem. And as I said, 99% of the applicants completed that examination in Michigan. Also, the ExamSoft also provided the software for the baby bar examination in California, and that was completed successfully. There are always improvements that can be made in the software, and I think they're working on those. There will not be live proctoring. I want to make that clear, make sure the board understands there will not be live proctoring. It's done by uploading a video that will first be evaluated by artificial intelligence, and then any questionable videos will be reviewed by the staff. So no decisions will be made by the artificial intelligence software. So we're moving forward with that. I know that other states that were planning to use ILG, including Florida, Illinois, and New Jersey, are expected to also participate in the online examination on October 5th and 6th. That will be administered by ExamSoft. So that's about it for the examinations. We do feel confident in the plans that they can be effected. The report for July is that 5,678 people took the July in-person exam in 23 different jurisdictions. And we have not heard any reports of any problems with infection occurring at those sites. there was a report of someone who tested positive for the virus who had actually been tested before the examination. And there's been no report of any consequence from that. In fact, the health authorities in Colorado said that the person had been adequately distanced from others and that there was no personal contact that would warrant any need to do further investigation with regard to that person. So we think that's pretty good evidence that an in-person examination can be administered safely. We're continuing to watch for any reports of any problem, but we haven't heard anything yet. And the information I just received about the July examination is that the MBE scores are good. They're good for July. So that indicates that it was an effective experience for the applicants as well. And we've already done D, which is approval of the contract with ExamSoft.
Right.
That's underway. So I don't really have anything to add on that. And the retirement announcements, Alan Cook, who had previously announced his retirement as general counsel and postponed that retirement date to help us get through the administration of the exam, what we thought would be July is now September and October, has notified me that he will be formally retiring finally, really and truly this time, October 31st. And so we are, we're circling back and preparing to find someone to take over that important role. And we really appreciate Alan postponing his retirement so that we wouldn't have to address that vacancy at the same time that we're dealing with all the other unforeseen challenges of this year. The other retirement announcement is myself. I am retiring at the end of this year, effective December 31st. That's something that I've been planning for quite some time and is not really related to the challenges of this year. But I did want to give the board advance notice about that. Then the last thing is, well, we've got the dean's letter, but I think, did you want to discuss that now, Chairman?
Let me say this. First of all, board members, Susan had notified us that she, at some point, she was going to be retiring, and also Alan, and we appreciate Alan's service and staying on beyond when he had originally considered leaving to continue to help us. And both Susan, both you and Al have been invaluable and real steady rocks for us to lean on during this time. So we appreciate everything you're doing. Board members, I'll just let you know this. I have been meeting with the executive leadership, Vice Chair Giltner and immediate past chair, Mr. Al Lodum, and we've been discussing plans going forward. And I think we have a closed session item agenda on the agenda a little bit later that we can actually go over some of the details. But I just wanted to publicly acknowledge, Susan, that we're very, very grateful for your commitment and hard work. And so thankfully you're still here and you're going to see us get these things done. So the dean's letter, board members, I think it's relevant to say this. We took this up last Wednesday, and remember that one of the urgency time is of the essence emergency basis for meeting was that we told you that we were going to be meeting, Susan and I, or at least appearing with the Texas Supreme Court and giving them a report. We did that on Friday afternoon. What I can tell you is that all of the input that was provided on Wednesday was presented to the court. Susan also had an opportunity to brief the court with an update on plans for September and for October. And I don't think I'm out of line to say that the court was very appreciative of all the hard work and would want me to extend to each and every one of you board members their thanks for the commitment you have to this process and everything that we're doing, as well as to the staff, Susan. I mean, I think it's important for them to know that the Supreme Court, told us they were grateful and expressed their thanks for what we're doing. And so I know that we started kind of a brainstorming process on Wednesday. I think, again, if we're not discussing backup plan publicly right now, there are reasons for that. But I would like to say to the public in general, we very much hear you. We very much understand that, and that is very much on our list of things that we are working on. But board members, I didn't know. I wanted to give you all an opportunity. Again, if you had any other thoughts, I mean, many of you spoke to the issue of an apprenticeship program or having a backup plan. If there's anything else you would like to add to, in addition to the comments that you made on Wednesday, I'd like to give you an opportunity to do that at this time. And you may not. I mean, I'm not trying to force anybody to say anything. I thought we had a very good airing out, and more to come. I mean, one of the things we're going to have to do before we adjourn for the morning is figure out when we're going to meet next, because I know that you all want to stay on top of this, and we have to continue to meet as a board like this if we want to get together to talk about things. But is there anything else that anybody wanted to add? Fair enough. So, Susan, anything else under the executive director report?
No, we've been meeting so frequently that I think everybody's pretty up to speed on the agency operations. So I don't have anything to add.
Right. Okay. And I just wanted to add that board members, thank you all. Susan's right. We're meeting quite a bit. It was great to see you all at the grading workshop that the board held 2 different sessions on Saturday. I thought that was very good, and I appreciate your commitment to that, and also that of our graders. I think everybody is ready and understands that we're going to have a challenging task at hand, getting everything graded, but I think everybody's up to the task and ready to go. So, all right, if there's nothing further, Ms. Henricks, then we'll move on to Ms. Drish, the report of the Director of Character and Fitness.
We have 2 agreed orders to be considered and approved by the panel. They were provided to you, I believe, in your board book materials, the confidential materials. Since we're in public session, we won't use their names, but they also don't have docket numbers listed. So we'll just use initials, which would be, we have an order for HP and one for TJ. The applicants have agreed to the conditions in the orders, and they have signed the orders already. So we are just waiting for approval from the board.
So the way we handle these, board members, if there's any deliberation, further deliberation that we need to do on this, we can always go into executive session for that. But is there a motion to approve the proposed agreed orders as recommended by Ms. Drish?
I move to approve HP and TJ's agreed orders.
Thank you, Ms. Thor. I've got a second from Mr. Odom. Thank you, Al. Okay. All in favor indicate by saying aye or raising your hand in the screen, please.
Aye.
Motion carries. Thank you, Ms. Drish. The agreed orders have been approved. Anything further?
Yep, that's all I have.
Thank you. Next, Nadia Wong. Ms. Wong, the report of the Director of Eligibility and Examination. And by the way, I didn't mean to leave you out, Nadia. Ms. Wong also helped with our appearance before the court on Friday, and provided some good technical background. So appreciate that, Nadia.
Thank you. Susan has, given a pretty good report on the plans for September and October. We did have a grading workshop that was attended on Saturday by all the board members. Thank you very much for attending that, and all of our current graders. And I think it was a great workshop. We engaged the services of a very, very, very experienced grader, attorney grader who gave us a really good presentation. And the reason we're doing this again is so that we can grade September faster and get the scores out faster. And we are really still hoping to get the scores out in early November, so that even though our applicants may have to study for a longer period, their eventual licensure really shouldn't be delayed by the shift in the exam from July to September. And that really is all I have on item 6.
Okay. Thank you, Ms. Wong. I didn't mean to steal your thunder. Yes, but thank you, Susan, Kai, Laurie, everybody else that helped with the graders workshop. I mean, Brad Rice is a longtime grader, very experienced, and a good friend of the BLEs, and he came and did I thought a very good job of helping us understand the attention we're going to have to give to grading, in addition to what we usually do, just because of the circumstances. So, but thank you all for putting that together. Okay, anything further? Is that it? Okay. Next, we have agenda item 7. We did have one public comment, Mr. Aragon, who did speak to this, and that's consideration of waiving the requirement. Well, let me go ahead and let Susan, you want to go ahead and tee that up and
I can.
For us to consider.
Yeah, Nadia can.
Nadia, I'm sorry.
Yeah, go ahead, Nadia.
So yeah, Mr. Aragon is actually the applicant who brought this to my attention a while ago. And we did talk about this at our last board meeting, but there are several of our UBE jurisdictions have agreed to administer the available NCBE materials that are available to administer remotely in October in a way that really does mimic a UBE. They've all agreed to use the UBE scale. So the scores will be reported in numbers that will be very similar, you know, so a 270 on this October exam would be roughly equivalent to a 270 on the UBE. They've agreed to grade it consistent with best practices and to attend the NCBE workshop and to engage a professional psychometrician to help them come up with the scores. I recommend that the board agree to accept these scores from the jurisdictions who have signed on to this memorandum of understanding as if they were UBE scores. That's my recommendation.
I'd move that we do that.
Okay, Mr. Soltero moved to approve the recommendation made by Ms. Wong.
I second.
Is that Mr. Massey?
Yes.
I think he went first. Yeah.
Yeah.
Massey or McKenzie, whichever.
Confusing me. I thought I heard Dwayne's voice first, Alfred. Sorry, but
yeah.
Okay. So motion's been made and seconded to approve the recommendation as presented by Ms. Wong. Any discussion? Any questions? Okay, then I'll call-
Texas component on this then becomes what?
As if it were a UBE score, so they would still have to complete our Texas law course before they got licensed.
So why would those who are currently taking our October exam not opt to do that instead and avoid the essays?
Well, I think what we're trying to capture here are the people who signed up because we're in a transition. Texas is in a transition right now. A lot of people who ultimately always planned to get licensed in Texas had signed up to take the UBE in other states. As those exams started getting canceled, a lot of them are just kind of stuck. You know, as Mr. Aragon pointed out, I've already paid to take the UBE somewhere else. I've already studied for the UBE, not for the Texas exam. And now I'm taking an exam that won't let me get licensed in Texas, which was always my goal and was the path that had been laid out by Texas until COVID. So I guess that's the answer, is that it kind of depends on what exam the people in July had already been preparing for. Were they preparing for a UBE that they were going to transfer to Texas? If so, this would allow them to basically do that. Or were they preparing for the Texas bar exam that we're administering? So I guess there's enough.
And just to clarify, you know, people who take our Texas online exam are just going to be eligible to be admitted in Texas. That's going to stay the same. And so we can't participate in these reciprocal agreements because the other jurisdictions are not going to accept our Texas score that's going to be on our 1,000-point scale with all Texas, doesn't include all the UBE elements. So it's just these people who are taking this online UBE
And since I'm the most junior board member, and I wasn't here for some of this, my understanding, and please correct me if I'm wrong, is that the Supreme Court had adopted saying we're going to go to the UBE, and then there was some, I'd say, movement to postpone that because I think we would otherwise have been doing the UBE this year. Am I wrong about that, or?
No, there was, you know, just a concern that we were switching, you know, midstream, that a lot of Texas law students had planned their courses, assuming that they were going to take the Texas bar exam. That's what they were expecting. And so that's what we're giving them. And so there was this period of transition. The task force had actually recommended that we switch to the UBE earlier, but we did, the court did listen to some concerns from some of the law schools. And so Anna, to answer your question, nothing would prevent them from switching. I don't think there's a problem really for them to do that if that's what they want to do. So.
Any other questions? Barbara, is that a question?
Well, what I heard Carlos say is that he thought that we had originally planned to give the UBE this year, and I don't believe that was ever the case. Maybe I misunderstood you.
Yeah, we're accepting UBE scores before we're actually giving the UBE.
Right.
So we're in this very unusual transition period that got complicated when the UBE states started canceling their UBE.
So basically, we're just accepting a UBE score as we plan to do, but it happens to be a modified UBE because of COVID. That's what we're voting on. Okay.
So normally we get the UBE scores from NCBE. We don't get them from the individual state that administered the test. NCBE is not going to report scores from the October online test as a UBE score. They're not going, because they're not going to put that data into all their other data, and they're not going to equate it, and it's not going to be scaled. You know, they're not doing anything except just giving the states the questions. So that's the reason for this need to waive the requirement that the score be reported from NCBE. We're going to accept this sort of modified UBE score from other states.
And Susan, what will the minimum score be since it's a different test?
It'll still be 270 because, as Nadia said, it's still going to be graded on the same scale.
Okay.
So yeah, we don't have to change any of that.
Great.
Any other questions? Then I'll go ahead and call the question. You've heard the recommendation presented by Ms. Wong. We've had an opportunity to discuss it and ask questions about it. Motion's been made and seconded. All in favor of the motion indicate by saying aye or raising your hand in the screen.
Aye.
Any opposed? Okay, motion carries. Thank you very much, Nadia, for presenting that to us. All right. On to agenda item number 8, and perfect timing. I see Mr. Cook and his wonderful countenance just showed up on Zoom. So I'll ask first of all for just a report. We do have a closed session or an executive session item to meet with council, but Mr. Cook or Ms. Bradshaw, I know you're on as well. Anything we need to hear from you in terms of reports?
Not in the open session.
Okay.
Chairman.
Lynn, are you on?
Sorry, no, I don't have anything to report.
Okay.
Thanks, though.
Thank you very much. Okay, sure. Thank you both. Okay. So now the capture all agenda item that we always include, number 9. Are there any issues arising from any of the reports that we have been presented this morning, board members, that you'd like to discuss or follow up on?
Well, Augie, is this where we discuss the proposals from the deans and the comments we heard earlier?
We can, Alfred. I was Sure. I mean, we had it back under the report of the executive director, but I mean, if there's something you'd like to add.
Well,
Yeah.
and the only comment I had after Ms. Hendricks gave the report is we ought to keep separate the issues of administering the September and October exams the way we've planned from the separate issue of whether we are going to consider an apprenticeship. And that's why I wasn't quite sure if that fit within her report. Certainly, Ms. Hendricks explained the precautions we're taking and the options that we ought to make available to the students, to the graduates and examinees, and in keeping with what the Supreme Court has already ordered. It seemed like most of the comments we heard wanted to put those together as an either or. And I think we just need to consider the apprenticeship separately from the October and September administrations.
Okay.
Commenting on Alfred's comment, I guess I would say that I think our staff has more on its plate right now than we could ever have expected them to deal with. And I don't think, as long as we're not going to have an apprenticeship program where the court hasn't asked us to examine an apprenticeship program as an alternative to the tests that we're going to give, then I think that is something for a later date once we're done with the administration and grading of the 2 exams that we have going on.
And I think, Mr. Rivera, my point there is that there's not as much urgency is what I heard today in determining the apprenticeship program. Unless people want to know, they can do that instead of taking the September or October. It does sound like a backup plan, as Dean Berry said, which means we could decide this in October. But if the court is looking right now for a recommendation, I would at least say when they consider the proposal, it needs to be tightened up. If they're going to consider an apprenticeship, there are things like the supervisor can delegate that authority, or anything related to, the mentor's practice, any and all. I mean, some of those things would need to be tightened up. My sense is that the court is going to look at it and consider it. And even if we don't have a recommendation, I want them to know that there are probably some things that need to be developed or studied further before we could make a firm recommendation.
Some of those comments, Alfred, were made, as I recalled, last Wednesday, and they were reported to the court.
Okay, good.
Yes, Ms. Orr?
I just had a general question for the staff because I think people ought to know, how far out from a bar exam administration do we start planning for it? I just think folks ought to know how far out we start planning for future exams.
Well, we start getting the site contracts in place, up to a year in advance.
Okay, thank you.
That answer the question? Good, all right. Any other comments or questions?
Mr. Rivera, has the court communicated any response to the communication that you, Ms. Hendricks, and Ms. Wong had with it on Friday?
We haven't received anything official from the court, Dwayne. We presented our report, and again, it included not only the points you made, Alfred, but the fact that there was some sentiment expressed in the conversation that maybe it should be something that that we look at and consider as a backup. I mean, so the court, I'm comfortable. Susan, you were there. Nadia, you were there. I think we reported everything that was brought up at the meeting on Wednesday for their consideration.
Yes, including.
Let me ask you a different question then.
But we haven't received any orders.
Right.
So.
We haven't received any orders from the court. Has there been any communication or response from any presentation made to the court?
I had a conversation with Judge Busby afterwards, and I understand the court's going to be taking it up at some point this week. But we don't have anything formal or official.
Do you have anything at all?
Just what I said.
Well, I think we could say, Augie, that the court expressed appreciation, like you said.
Yeah.
They're very much aware of our efforts to accommodate the needs of the applicants by fulfilling the court's last order of July 3rd. They are very, many of them, I don't know, they didn't all speak to this, but many of them are very pleased with the plan to administer the examination in the hotels. They are optimistic that that's going to be a very good, effective approach. So I think they're, as I said, appreciative and supportive of our work. That was my sense. Would that be fair, Augie?
Yeah, I mean, just as I reported, and I'm not trying to play coy or anything, Dwayne. We have an order from the court that we're complying with and moving forward on, and we expect that they will let us know formally and officially, what to do next. Hopefully, sometime this week.
If there is no order, then we just proceed with the one we have.
Right.
Question?
Is there a question? Yes, sir.
Yeah. So it sounds like it's our consensus that we don't or shouldn't take any position until we're invited by the court to do so. Is that basically what we're saying? On the apprenticeship thing.
Unless there's something else, I mean, I'm one member, so I mean, if there's a consensus that we take up the apprenticeship proposal as something we want to more strongly recommend or recommend at all, we can do that. I don't want to cut anybody off or cut us off.
And I'm not suggesting one way or the other. I just, it's not clear to me. Maybe it's clear to others. We heard all these folks urge us to recommend to the court to do this. And we currently have an order from the court telling us what to do. And it's not clear to me whether procedurally or whatever you want to call it, it is necessary or appropriate or advisable for us as a board to go to the court and say, we know you sent us this order, but we've listened to these folks and we formally recommend that you do this in addition to what you did in the order, or whether we've done what we should do, and that is report to the court what we heard from these folks and let the court decide what action it wants to take or what further direction it wants to give us.
I guess I just want to remind everybody that we had the apprenticeship program in front of us when we initially recommended that we just have an October exam, and the court clearly considered the issue of an apprenticeship program when it met and told us to go forward with an October and a September exam. And I know that the deans came back with another letter that purports to flesh out the program more, and that was sent directly to the court. And I think procedurally, if the court wanted us to do anything further on it, I think they would have come back to us and asked for our opinion, or without our opinion, they could have come forward with another order. And absent that, I don't think it's something that in the middle of trying to administer 2 exams that we should have our staff have to deal with to flesh out more what was in the dean's proposal. I think we're at a point that if the court wanted more from us on this, it's in the court to send the ball back to us, and they have clearly not done that yet. that's my summary of it. And if I'm wrong about that, I'm sure one of you will correct me.
No, I think that's generally right, Barbara. That's the perspective I have. Ms. Orr, Cynthia?
I just wanted to share my kind of thinking about where we are on this. I agree with Barbara's observations. I do know that the court had it in front of it and then we got the order. I think that, well, I have a UVA law clerk who took the in-person exam, and that was a really largely social distanced exam. And I think it's important to think about that because in my mind, everyone may be hoping for a vaccine to harness the emergency situation the pandemic has created by the end of this year. I'm not making that assumption. I don't think we as a board can make that assumption. And I think that the planning I know we're doing going forward is not making that assumption. So I think that the only reason I was still entertaining this topic is not because I think that the court wants us to make a recommendation prior to the exams that they've asked us to hold, but in terms of forward thinking. And I know that the ABA is reconsidering what law school should look like and what bar exams should look like and the like. And I know we'll always change to try and get better. That's our goal. And so I think that, the reason I was entertaining it in the prior conversation is because I don't think we're done dealing with this pandemic.
May not be.
Right. And I'm looking into, 2021 and going forward, and also considering that at some point we're going to hear something from the ABA about the whole ball of wax. And I want to keep an open mind and have these informed discussions. So I didn't want to mislead by discussing at last meeting, thinking that, we would do anything other than what the court's ordered us to do. But I think we always have to think about moving forward and thinking about the future.
Agree. Board members, I think Barbara put it exactly where we are. I mean, we've had discussions and actually some, I think, constructive deliberations even amongst ourselves. I think, the apprenticeship proposal or concept as it was put by the deans, you all had the opportunity to read the letter. We had a chance to discuss it last week. I thought what I heard, though, each and every one of us is acutely mindful of what's going on right now. We all know where we're at, and we are planning and preparing for the administration of 2 bar exams in the next 60 days. And we've been, presented with reports on what those plans look like. And that's how we're moving forward in order to comply with the order of the court. Like Cynthia says, I mean, does this mean it's fixed? It's hard to say, right? If there's anything we learned that nothing is fixed. But I think Barbara is correct. We follow direction given to us by the court. And look, there were some, while there were some positives about the concept of an apprenticeship component as part of licensure, I also heard some very specific concerns about there's not enough meat, I think, to quote Ms. Ellis, on the plan, and that there are plenty of details to work out, and how you administer or implement that. We're trying to administer a 2-day bar exam, right? How do you administer a 4 to 5 month apprenticeship program under the same challenging circumstances? So lots of questions, but I mean, I think I don't know that the board is prepared to make a recommendation on that in a formal way where we change, where we do anything but stay the course. So we'll see. Carlos, you had your hand up.
Yeah, just some very quick questions and observations. Susan, in a normal year, had COVID never come upon all of us as a society and community and world, when would the July exam results have come in, we would expect? At the end of October, early November?
Yeah, we always strive to complete the grading and scoring by November 1st.
Okay, so we're still we're still within a time period under which if everybody had taken their exams, nobody would know what their result was at this point. Okay.
Right.
And then secondly, you know, the court, like all of us and like many of the people who come to us and made public comments, is personally and painfully aware of how strongly COVID has impacted certainly this state and our country. And I mean that they personally are aware of it. And so they certainly are taking that into consideration when they're making their decisions and the safety of everybody involved. Is there anything that we as a board have by way of information to provide the court that hasn't already been provided to the court?
Well,
I don't think so either. And so I guess what I would say is to echo what Barbara said, what I think what Al said, what Cynthia said, we have orders that are very clear and they're going to be followed and executed, and it's still a fluid situation. And I would just like Cynthia said, we're going to keep an open mind and keep evaluating all the proposals at the right time is my take, and that's all I have to say.
Yeah, I think that's a fair summation. Sorry, Barbara. Go ahead.
At some point, could we get a report from you or someone about what is the NCBE doing about going forward with its study about the bar exam? Because I think a lot of this talk about apprenticeship should be definitely coordinated with the idea that the bar exam itself may be changing. You know, there may be recommendations to make changes in how we administer an exam of some sort for professional licensing. And I've been wondering if they put that on hold because of COVID, or are they continuing to go forward with it?
Quick answer, but great point. The National Conference of Bar Examiners for almost 3 years now has been conducting a study and evaluation under a testing task force where they have, some of you may have participated in focus groups, some of you may have filled out a survey, but they're taking an ambitious big picture view of beginning, first of all, with what sort of skill sets are expected of newly licensed lawyers in the 21st century, and then looking at ways to improve, you know, the process of licensing and credentialing. My understanding, Barbara, is that I don't think there's been any kind of delay, but I don't know that they're you know, because of COVID, you know, I'm not sure that they're still going to be announcing results of that in the fall. They may be, but I mean, but it's coming. So for further discussion at a future board meeting, Nadia and I will be happy to get you up to date on that.
Thank you.
Yeah. And let me just say this, board members, I think several of you have said this. I mean, Carlos, you put it more eloquently than I could, but I mean, we are still in a state of flux. And so, you know, I don't know, we may get other marching orders from the court. And I will tell every one of you, we are ready to serve, and we'll take it up at that point. So I'm not sure we're completely done with this issue, but for now, you know, we do have our marching orders and we're proceeding.
Mr. Rivera, I'd like to ask just one question to make sure that I've got the timeline right. When we proposed to the court an online examination, the court took it upon itself to also add the in-person examination as well?
Yes, that's correct.
And would it be fair to say that we're an agency of the Texas Supreme Court, and that ultimately it's the court's responsibility for admitting applicants to the Texas bar?
Correct.
And would it also be fair that if the court were to decide that an apprenticeship option or some other option would be the way to go to provide as an alternative or a plan C, that the court does not need the Board of Law Examiners to make a recommendation for that to happen?
I'm not sure I would go that far. They still look to us for guidance and input. And I don't know. I don't know what that would look like. They may want us to play a bigger role in that if that's what they decide to do. But, you know, so far that hasn't happened.
Well, I'm using the example of a September in-person examination. That's not something that I recall we formally recommended to the court, but the court decided to do that anyway.
Right.
So if that's any in the, the past is an example of a prologue to the future, then the court could decide to do something else beyond the scope of what's been recommended to it by.
That's correct. And all I'm saying is that, to the extent, I mean, we may be asked to play a role in that, a more formal role. I just don't know. We are still charged with assisting the court on in the credentialing process and to execute the plans that they present to us.
Fair enough. Thanks.
Yep. No, thank you. Any other comments or input? I did tell the court that I have the privilege of serving with 8 of the smartest people that I know. And so you guys have not disappointed today. Thank you all for your input and as always, thoughtfulness on this. If there's nothing further, then is there anything further? Anybody else have anything else to say? Okay. Then at this time,
Mr. Rivera, there's one thing I'd like to say.
Sure,
I mean,
sure.
As the second youngest member of the board in terms of seniority, I would like to say thanks to Ms. Hendricks and Ms. Wong and the board staff, especially to them for always being one step ahead of where we needed them to be, and always having a recommendation or answer to a question often before the board asked it. So we will be forever in their debt for getting us to the point where we are and to the end of this challenging year. So thanks very much, Susan, Nadia, appreciate it.
I'd like to thank the chair for his accommodation of all interested stakeholders and Augie, for all the extra time you've had to put in and meeting with all parties, including the court, and making sure everyone's informed. Just really appreciate the extra work and your leadership during this difficult time.
Thank you, Cynthia. Thank you, Dwayne, for your much appreciated comments. It's what we do. It's what we do. That's what Susan. Susan says. Always say it's what we do. So, okay, team. Thank you very much. Okay, at this time it is by my watch 11:15. Anybody need to take a break, or can we just move into executive session? I don't think it's going to take long. Everybody okay with moving forward? Okay. So at 11:15, let me read this. The Board of Law Examiners will now go into executive session at 11:15 pursuant to Texas Government Code 551071, consultation with legal counsel regarding pending or contemplated litigation or a settlement offer with possible discussion and action in open session and the seeking of legal advice from counsel on pending legal or contemplated matters or claims with possible discussion and action in open session. Subpart B, Texas Government Code 551074A1, personnel matters regarding the employment, evaluation, reassignment, duties, discipline, or dismissal of a public officer or employee. So at this time, board members, please stay on. Ms. Hendricks and Mr. Cook, please stay on, and everyone else should be off the line.
Mr. Rivera, I'd like to ask how will we be coming back into open session at the end of the meeting?
We will. I don't anticipate that there will be anything that we need to act on. So,
unfortunately, since I'm administering the meeting, I don't know how to drop out and then be able to come back in. What I could do is move all of you into a private meeting room, and I will stay in the main meeting room, and that way I'm not participating in any of the executive session activities.
Okay.
When y'all are finished and ready to come back into the main meeting room, if one of you can just come back in and let me know, I'll close the meeting room. Excuse me, I will close the private meeting room and all of you will come back into the main room.
Okay, so here's how I see this playing out. We're going to do a short litigation or legal update with Mr. Cook and Susan. He and Susan will be here for that. Then I'm going to ask Mr. Cook